I think that's what he said. You know what? We're gonna get us some stuff.
All right. Ryan, who's here on Ryan Martinez?
That's when we approach.
Yes, and you don't have anyone on Zoom.
We should have a caseworker. Please,
Yeah, they never zoomed in.
I know, Your Honor, that she is in the middle of picking up or transporting a child out of state.
Okay,
So it could be that she's either on a plane
okay.
or somewhere that she might not be able to come out.
All right, well, I'll take whatever testimony y'all have, and then whenever she can zoom in, that's fine.
it's fine, Judge. A couple of things. Number one, we were also here this morning on a discovery on this case.
Mhm.
And I want the court to know,
Come up, sir.
I want the court to know that the indictment's back, I think, in February. I've been trying to get discovery, and the intake has been telling me it would be on Veripic, and it was never there. And as a matter of fact, as of July the 5th, there was nothing on Veripic. I went back to Hugo Sanchez, the intake prosecutor,
Mhm.
and he didn't have it. He was finally able to get it, and now he's downloaded on a passport that I've given. So about 10 days ago, I got the passport. There's tremendous amounts of documents on it.
Okay.
So I'm not anywhere near, and I assume I've got it all. I don't know for sure, but I know I've got tons of it to look at. So that's where I am in discovery.
All right, so Norma, on this case, give me a discovery date in 60 days. All right, so that's the discovery date. And then
September 24th.
before we go on the record, do you have the motion to modify?
I do.
All right.
I've got it too. Well, yeah.
Okay.
You
Oh,
do.
I have it. I
Okay.
just want to make sure everybody is on the same page. Court is calling 2026 CR 007780 State versus Ryan Daniel Martinez. Can I have parties announced?
Will Van Zeta for the state of Texas.
And Ron Ross for Ryan Martinez.
All right, and are you Mr. Martinez?
Yes, ma'am.
All right, we're here on a motion to modify bond conditions. Defense, what are you asking for?
I'm asking for the judge to reinstate his access to his children, visitation rights with his children that were afforded him from June last year until February of this year. The incident that we're here on today happened in June of last year. CPS got involved. They had hearings. There was a court-ordered visitation scheduled for him for his children in the through the CPS court system. And once he was indicted in February, CPS cut off all of his access to his children. And we're here today to ask the CPS, I believe, and his lawyer will testify, and I think the caseworker would testify also. CPS actually wants him to have a relationship with children, wants and encourages that the no contact order that was issued whenever he was indicted by a magistrate judge, that be rescinded, that he be reinstated his previous visitation rights with his children. They were all supervised, and they were all held at the offices of the Child Protective Services.
All right, so here's my question.
Mhm.
The children that the no contact order is with, or is it the twins or the surviving
Well,
twin?
Transmission.
So are there other children?
There's two older children.
And what are their ages?
6 and 5.
And I'm sorry, could you announce your name for the record?
Yes, Your Honor, my name is Rosie Reyes. I'm the court-appointed attorney on the CPS case.
Okay, and you're the court-appointed attorney for Mr. Martinez?
Mr. Martinez, yes.
Okay. So. What are the ages of all the children?
We have Mavis. Go ahead.
Mavis Martinez.
Oh, I'm sorry. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Ryan Martinez.
All right, so I'm not going to ask you about any of the facts of this case. I'm just trying to get the ages of the children. And then if your attorney wants to ask you some questions, he can do that, okay?
Yep.
So I don't need the children's name. I just need the ages of all the living children.
6, 5, and 1.
All right, and the 1-year-old is the surviving twin? And the case that we're on here today, is that related to the twin?
To the deceased child.
Yes.
Okay.
she's the twin.
You asked about, I don't know, here was the no contact order, the magistrate's order. It only addresses the two small children, I think, but CPS has cut off all his visitation to all his children.
And Your Honor,
Yes.
for your information, I've asked the child's mother, Valerie, to be here as well. If you have any questions for her, she is available.
All right, thank you. So the child that's listed in the no contact order, that's the surviving twin?
That would probably be both of them, Mia and Maya.
Well, they only have one name in there.
They are very similar names, unfortunately. One is Mia, M-I-A, one is Maya, M-Y-A.
I think that one has Mia
It only has
listed.
Mia,
Yeah, and Mia is not the surviving child.
that's a deceased child.
So where is the note? Because that only has that child's name for the no contact order. So
You're
And
right.
yes,
Immediately after this happened, I had a motion for visitation because they stopped the visitation because of the no contact order. And then the DA, I believe, modified it to include all the children.
Would
At
that be
one point.
the CPS prosecutor?
No,
The criminal?
all right.
because the CPS prosecutor wouldn't. have done that.
My understanding, the CPS will not let him have visitation unless this court orders that he can have visitation with his children, the two older children and the one surviving smaller
Well,
child.
I want to see where this other motion is. Just 1 second. All right, somebody sign a pretrial motion to modify conditions, and that had to do with working.
I did that earlier this year.
Okay.
This would have been last year sometime if through the CPS, they would have had a different case number too.
Okay. All right, we're off the record for a couple of minutes because I know we're going to start having a conversation over each other. All right, I'm trying to find to the clerk. Can you pull where somebody, thank you. So let's find out where this order is, who signed it, what it's about. But I am going to have to take evidence if it's an order in place and you all are asking for that to be changed. And then we'll go from there. She's gonna pull it. And State, are you gonna be objecting to this?
We are, Your Honor.
Okay. And parties, when you all have your arguments or whatever evidence you want to present, bear in mind, I know absolutely nothing about this case, only what's in the indictment. Oh, thank you. Oh, okay. Do we know which judge this was?
We've been judged on that.
Ah,
Oh, no.
okay. Alrighty. Now I see, we can go back on the record. So I am looking at the motion to increase and amend bond conditions. And this was signed by a judge on February 9th, 2026. And then that judge ordered no contact with all of the children. All right, now that we have that out of the way, the court will take any testimony. Defense, do you have any witnesses?
I would call Rosie Reyes.
All right, you're an officer of the court. You don't have to be sworn in.
You want to state for the record what your name is?
My name is Rosie Reyes. I'm the court-appointed attorney in Mr. Martinez's CPS case, Your Honor.
And you've been his attorney since almost the beginning of the CPS matter.
Since the 262 hearing.
And that was back last summer, maybe June or July.
That was last summer, yeah, between June and July, yes.
And the child is deceased. That's the subject that caused all this. She died in June, correct?
Yes,
And so after you became the lawyer, y'all eventually went to court
we had-
and
I'm s-
there was an order for his visitation rights.
yes, but as both parents get supervised visits, Your Honor, and both a mom and dad got supervised visits.
Yeah, what was his supervised visitation?
His supervised visits at the time that they stopped were weekly with his children, his two oldest at the CPS. It's monitored. It's in the CPS facility. His youngest child was in Killeen, Texas, in a foster home that had a nurse as a foster parent because she suffered some medical. She had a medical procedure that at the hospital that caused the result of the tearing of her larynx.
Mhm.
So she had a lot of medical issues. So they placed her in Killeen, and he would visit twice a month in Killeen, Texas.
And for how long was his visits when he went?
In Killeen, because of the travel time, he had 2 hours. And here in San Antonio, it was an hour.
Here in San Antonio, it was weekly,
It was weekly, yes.
1 hour each week supervised here, and
Yeah.
there it was 2 hours twice a month.
Yes.
And has there been any problems to your knowledge of visitation? Has there been any reports that they didn't work well? There's been a problem at all?
Your Honor, I've reviewed all the monitor's notes for every visit for all the children. And he is exemplary when it comes to his visitation with his children. So in a CPS case, when parents visit, they have to provide food, they have to provide activities for them during that period of time. They have to show appropriate parenting skills. Each and every one of his monitored reports by the monitor are excellent. In reference to his child in Killeen, the same thing. He was visiting, his mother was also attending those visits. So there was no complaints whatsoever with his visitation with his children.
And I want to make it clear, the visitations were supervised at the offices of the Department of Regulatory Services, Child Protective
Yes.
Services, right?
Yes, and in Killeen, they had a special place. They had a visitation center that she would be taken, and that's where the visits were. So the foster mom would also be there and was in contact with him on a regular basis, I believe.
Okay, so let me ask this. So the order for visitation was changed on February 9th, 2026. Before that order was signed on that date, was he previously having the supervised visitation?
Yes, Your Honor.
And how often had he had supervised visitation?
He has not missed any visits since the 262.
Since last July, perhaps, through until February?
Yes, so visits there, as you know, there's a staggered before they start setting up. He has not missed any visits with his children.
So
And-
this is what I can tell parties what I want to understand. Number one, what is concern about supervised visitation? Because I can tell both parties, based upon the information that I've read and the motion to modify conditions and the motion to increase and amend bond conditions that was filed by the state, I'm not doing a unsupervised.
Oh, no, this is.
Visitation.
We're not asking for it. I've asked for supervised.
Yes. So then the issue becomes, what is the issue with supervised visitation?
Your Honor, the state is opposed to it for two reasons. The first is a general concern the state has with any sort of visitation moving forward, which is that this defendant has previously been convicted in this court of causing injury to a child who received 18 months in the state jail from this court. That's a general concern that the state has with any sort of visitation. As to the supervised visitation, the representation of the children's mother who's here in this court, she's indicated to me that the children do not want to see the defendant as part of visitation. I understand that the court will order visitation whether the children want it or not frequently. However, the state believes that if the children do not want to see.
Well, I will tell you, part of the the issue that needs to be addressed then is what does the child's ad litem, what do they say?
Mrs. Stout, I am uncertain at this point. I'm assuming she's also opposed to having visits. But at the 262, all this information about his prior case was known.
Mhm.
Visitation was not restricted at that point. And he was having visits on a regular basis and doing the visits. So there was no issue up until the criminal case was finally filed against him. And at that point, talking with the CPS prosecuting attorney, the only reason that the visits weren't happening is because of the criminal case. So it wasn't their fault that the visits weren't continuing.
Mhm.
It was the prosecutor in the criminal case that was hampering that. And so this is where we're at now. So every time I file a motion for visits, they go, well, Rosie, it's not us that are stopping these visits. It's the prosecutor here, or it's what's noted that's stopping the visits. And that's the only thing that's stopping the visits.
Couple of more questions. if I might.
Yes.
The mother, the children are not living with the mother, are they?
Not at this time. The goal is to reunite the children with mom. The youngest child who was in Colleen is now here with a relative. I believe it's her aunt. And she has not yet, I think, been placed. So mom's had extended visits. I'm not certain how well those visits are going and how frequent those visits are. She does not have the youngest one that has special needs, requires a special bed, requires special feeding because she's got a feeding tube. And so when that transition is going to happen, I am uncertain.
Well, another question. You know, the caseworker on this case, what's her name?
The caseworker is Lisa Gaines Brooks.
Educate me. Is she the caseworker for the children? All parties? Who does she
She
caseworker?
represents CPS. So obviously, I always tell my
Yeah.
clients, she is always looking out for the best interest of the children.
Mhm.
At the last staffing that we had, or the last court hearing we had, they're not seeking to terminate him. Like I said, he's an exemplary dad. There's no indication on any of the records, and I reviewed them because I take it very seriously when this has happened. And there's nothing in there that says that he has been inappropriate, that he is not prepared when he visits with his children. I think there was only one time, his little boy is very energetic, so he likes to horseplay. And the monitor said, let's not do that. And that was the only time over the numerous visits that he's had with his children.
Does the caseworker, to your knowledge, does she have any objections to reinstating visitation?
The caseworker doesn't have any objections. And as talking with the ADA in this the case,
Mhm.
she said, it's my hands are tied because
Who's the ADA?
it's Sarah Spears. What's Sarah's last name?
Let me ask you this. Is there,
I'm sorry. I just, after a while, you just.
Yeah.
you were talking about terminating rights. Is there a concern if he doesn't get his visitation back that the CPS may move to terminate his rights?
So at this time, we were set to go to trial. We have a jury trial that was set for August. That has been extended. It's been extended to get the children placed eventually with mom and the little one placed with mom. So they're giving her more opportunity to have that happen. And so that's why we went to like a pre-settlement kind of conference. And at this point, like I said, Your Honor, the CPS and the caseworker are not seeking to terminate.
All right.
How about his rights? Are they seeking to terminate his rights?
They're not seeking to terminate either one.
Would that be a possibility if he doesn't get his visitation right?
The problem is he hasn't had his visits in the last 6 months. And those visits, the children look forward to him every week. Now, I understand mom is going to say, and I've heard it in court, that the kids don't want to see him anymore, but he's been denied access for 6 months. They were placed with the grandparents, the maternal grandparents. So I do family law, you know how that goes. So my honest feeling is that once they have visits, the moment they see each other, it's going to be fine.
I'll pass the witness.
So the current goal of Department of Family Protective Services is family reunification.
Yes, it is.
That can change.
It obviously can change.
And frequently, when they seek termination, they have the goal of family reunification up until the point when they decide to seek.
Yes and no, because this case was extended, it's reunification. And it's been reunification since day one.
No further questions.
Just one question to my client. If I don't want to get, we're not gonna get into
Well,
facts.
I mean, before you do that, so are they looking at joint managing
You're-
conservatorship?
No.
But
What we.
managing and
She will
possessor?
become sole managing of the children and he will be possessory. His visitation, even afterwards, would agree that they stay supervised until this criminal case matter is settled one way or another.
Right, thank you so much.
You're very welcome, Your Honor.
I'd like to ask my client one question. If
Sure.
you want to swear him in or not.
Oh, I've already, I sworn him
The
in.
prior offense that you had that you went to prison for, what was that about? It was a baby, right?
Yes.
And what happened there, just briefly?
I was just taking a shower with her
You
and
drunk.
she slipped out of my hand.
And she was how old?
She was 2 months.
Okay, that's all. Pass it with us.
But you were convicted, you pled. True, no contest or guilty to the offense of injury to a child causing bodily injury to recklessness, and you served 18 months in the state jail facility.
Yes.
So all the witnesses, Judge.
All right, so let me just tell the parties what my concerns are. and
Can I
maybe-
tell you one thing?
Sure.
The order that was, I guess it was signed by this court in February, Daryl Harris sent me a copy of that.
Oh, no, I didn't sign the order. Someone else signed it.
Daryl Harris sent me a copy of with the motion to set. There was never a setting on it. I was never given notice of the setting
Mhm.
of that particular hearing on that thing.
Yeah, this is not my handwriting.
Well, okay, but I was never given a notice of a setting on that. So it was signed without notice to me.
Because I always give everybody notice.
I knew you,
Yeah.
would, I was kind of surprised.
Yeah, and Your Honor, I was surprised because there was just a change and he was having this visits. We actually had a CPS hearing during that time.
All right, so these are my concerns and maybe you all can address them. And maybe it's addressed through different witnesses. Number one, I am concerned about the fact that he's been to prison, well, to the state jail facility before for injury to a child. So I would like to refamiliarize myself with the stipulated evidence in that case. Then my other concern is, and I know you're an officer of the court, and I've known you forever, but the child's ad litem, I would really like to hear from them because they're 100% supposed to be looking out for the best interests of the children and they're the ad litem. And I would like to find out from either the person who supervised the visitation or either from the therapist of the children to see if the children really want to see him. Some people are going to say no, they're afraid of him, they don't want to see him. And maybe some people will say yes. Disinterested party, well, I should say the party who should not be biased would be the therapist or whoever it is. So I would like to hear that, and then I can make an informed decision that hopefully protects everybody.
Can we reset that for maybe next week or?
You all just discuss on when this can happen and any objections to anybody appearing by Zoom, because I know caseworkers and therapists are very busy.
No.
I have no problems.
All right, so this is what I'll have you all do. He's set on the docket in September for discovery, but of course we want to do that before then. So if you all will discover when these witnesses will be available, and you can put it on the docket whenever you want to put it on the docket, and I'll make sure I'm here.
Okay, does the clients need to be on present or they do it on
Oh, they
Zoom
can be
too?
present or they can be in Zoom
Maybe-
or Zoom, however, what is easiest for either party.
I can be on Zoom or in present, Your Honor. It just depends.
Okay,
So if you guys just figure out a date when everybody can be here, and then I'll make my decision.
all right.
Your
All
Honor, would it be helpful for you to see the certified notes for the monitor, or do you want to speak to a monitor? Sometimes they have different monitors.
Yeah. Oh, I tell you what, if you all will review the certified notes, and then if y'all feel like I need something more than that, let me know. I keep an open mind.
But you
Okay.
primarily went to therapist and the ad litem.
Yes.
Your Honor, as to the stipulations in the prior case, that was out of this court.
Yes.
I'll be able to find those stipulations, present them to this court.
Yes, and also too, yes.
Okay.
To
That'll
the
work,
defense,
that'll work.
if he doesn't object.
Okay, awesome. All right, thank you, guys. Oh, and once he signs the reset form, he'll be excused.
She signed it.
And you all just let Norma know what's a good date for everybody to be available.
That was all the time on the document. I'll be excused.
Yes, you may be excused. Thank you.
Yes, I did.
All right. We have Antoine Irving, Mr. Yan. Okay. Then we have Eloy Orozco.
He's in the box pitch.
All right, Mr. Orozco, if you'll come down.
Judge, he's away. On that one, defense is still out of county in federal court. He's got, he can come back tomorrow.
All right, Mr. Roscoe, how are you doing today?
I'm doing okay. How are you?
I am doing great. I can't complain.
He might be-
All right, so they're telling me your attorney's in federal court. Federal court takes precedent over state court. Have you had a chance to speak with your attorney?
I have not.
Have you ever spoken with him?
Never.
Just 1 second. Well, I think this may be your first setting with this court. So what we're going to do, we're going to recall you for tomorrow. If he's not here, then we'll address it, okay? All right, thank you.
I can't be appointed another attorney at this. time?
Well, we're going to recall it tomorrow.
Okay.
We're going to see if he's here, and then if there are issues, then we'll address it at that time.
Thank you.
You're welcome.
All right, come on. Here you go. Sorry about that. Let's go back here. Mhm.
Okay, and then Roderick Walker. Can you find out where Mr. McLean is? All right. Then we have Michael Hill. All right, this is a motion to suppress.
Yes.
All right, are parties ready?
Okay.
It's the,
Okay. All right, as soon as he comes back, we will start. And on this one, can I see the motion to suppress, please, if you don't have it?
yes.
And I'll give this back to you.
Work on an unrelated case, Judge.
Yes.
It's set tomorrow.
All right, thank you.
Thank you.
You. And defense, before we go into record, what is the issue? Is it the stop? Is it a search? What's going on?
It's we believe it is a search judge. We believe that there is an unreasonable delay between the stop and the search. So we're just challenging reasonable suspicion for that,
Okay.
for the search.
And is there a warrant involved or no?
There's not.
Judge, we'll stipulate that's one.
Okay.
Well, I think it's more, it's a warrantless search. We're not challenging the arrest
Okay. All righty.
or whatever that's worth.
All right. Thank you.
Thank you.
All right. Is your client going to take a seat?
Would you like him to?
Sure.
Yes.
Have a seat. Yes.
This one? You don't think I'm loud enough? Okay. Test settings.
Sure. And counsel, the search, was this a vehicle?
Yes, Judge.
Okay.
I'm sorry. Yeah. Judge, can we have our witness on the stand?
Oh, and let me know when y'all have the motion. All right, court is calling 2026 CR 00139 State versus Michael Hill. Can I have parties announce?
Yes, Judge. Brandon Prater and Lauren Espinoza for the state.
Jason Todd and Victoria Hassett for Mr. Hill.
And are you Mr. Hill?
Yes, ma'am.
All right, we're here for a motion to suppress off the record. My understanding, sorry, we're on the record. But off the record, parties stated that that this was a warrantless arrest and search.
Yes, Judge.
And state, you said you're stipulating to that?
Yes, Judge. We'll stipulate this was a warrantless search. The burden has shifted. We're prepared to proceed.
All right, state, you may proceed.
Thank you, Judge. We'll call Officer Andrew Vasquez instead.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so everyone can hear. If you'll state your name for the record and spell your last name.
Andrew Vasquez. Last name Bacquez.
All right, state, you may proceed.
Thank you, Judge. Good afternoon, officer. Can you say for the record, what law enforcement agency are you commissioned with right now?
Universal City.
Okay. Were you commissioned with Universal City Police Department on July 17, 2025?
Yes.
What were your duties on July 17, 2025?
Patrol.
Okay. Can you go through? What would you?
I'm just looking for my highlight.
Okay.
You're totally different. Thank
All right, officer, did you perform a traffic citation that night?
Yes.
Did you write a report based on that traffic stop?
Yes.
Would a copy of your report help refresh your memory?
Yes.
You already have that report in front of you?
Yes.
Okay. So, when I ask you a question, feel free to read from the report to refresh your memory, but because it has not been in the evidence, you cannot read directly. Of course, Judge. First of the record, I'm showing what's the label State Exhibit A to Defense Counsel.
Okay, you may proceed, counsel.
Thank you.
So officer, what was your rank on July 17, 2025?
From,
What are the duties of a patrolman?
we conduct traffic security checks around the city. Welfare checks and check on businesses.
Okay. And when you said you work traffic, what does that mean specifically?
Traffic enforcement, so we conduct any traffic violations, do a traffic stop.
Was your vehicle that night equipped with a radar LiDAR device?
Yes, that's correct.
Are you trained on how to use radar and LiDAR?
Yes,
Can you describe to the court what radar and LiDAR is?
so radar is equipment that works with K-bands. So if there's a moving object or there's a moving object approaching my vehicle, it sends out K-band readings. So it'll bounce off of the vehicle and comes back towards the radar, and it'll read a speed for that vehicle.
Okay, and you were certified to use that equipment by the state on July 17, 2025?
Yes,
Okay, let's go to the odor of marijuana. Were you trained on the odor or scent of marijuana?
due to my training experience with police officer.
Okay, can you describe your training experience with the odor of marijuana?
Different encounters during FTO, burnt marijuana, and also fresh marijuana.
Okay.
So it's like a leafy green substance.
Okay, but you're familiar with the scent of marijuana, whether it be burned or unburned?
Yes,
So let's go to the night of July 17th, 2025. Did you pull over a white Infiniti that evening?
yes, that's correct.
What was your reasoning for pulling over the white Infiniti?
For speeding,
Okay. What was the speed limit on the road that y'all were on?
45,
What was the speed limit that the radar LiDAR came back with?
70.
Okay, is this in excess of the speed limit?
Yes,
Is that a traffic violation?
yes.
What did you do next?
I turn around the vehicle, then I activate my overhead lights, and the conducted a traffic stop in front of Randolph Air Force Base.
Okay. Did you get out of your patrol vehicle and approach the white Infiniti?
Yes,
Okay. Was the window down or up when you approached?
down.
Okay. When you got to the roll down window, did you observe a person in the vehicle?
Yes,
Okay. Was that person later identified as Michael Hill?
yes,
Can you point him out for the court? Reflect that the witness identified the defendant. Now, when the vehicle window was down, did you smell any scents emanating from the vehicle?
yes.
What was the scent that was emanating from the vehicle?
Marijuana.
Is it possible that scent could have been emanating from somewhere else, was blown in by the wind or something like that?
No.
Your sense was that it was coming from inside the vehicle?
Yes.
Okay. How did you proceed next?
I continued my traffic stop, asking them basic questions, and from there, when I detected the odor of marijuana, I called for a cover officer.
Okay. What'd you go for a cover officer?
So in Universal City, anytime we have probable cause or a reason to have another officer assistance for officer safety.
Okay. So you believe that you have probable cause to search the vehicle?
Yes,
What was that probable cause based on?
based on detection of marijuana, odor of marijuana emitting from the vehicle.
Okay. Did you handcuff and detain Mr. Hill?
Yes,
Okay. How long in between the stop and the actual search of the vehicle? How long was that in minutes?
not sure.
Could you guess, like, was it like 5-10 minutes?
During the traffic encounter,
Yes.
5-10 minutes.
Okay. Did you call for any kind of drug sniffing dog to search the vehicle?
No.
Okay. What were there was any contraband found within the vehicle?
Judge, I'm gonna object to this question. We're not challenging. If what was found was challenging the search.
All right, that'll be overruled. The court will hear it.
Okay. What was the contraband that was found in Mr. Hill's vehicle?
Baggies, a scale, marijuana, and a firearm.
What did you do when you found all of these items?
So we collected as evidence. See,
Did you make an arrest?
yes,
After the arrest, where did you transport Mr. Hill to?
2150 Universal City Boulevard, or Universal City Police Station.
Okay. Did you talk to Mr. Hill about where this contraband came from?
Yes,
Did you Mirandize him first before you asked him these questions?
Judge, I'm gonna object to this. This is not what we're challenging.
So what is the
Judge,
purpose of this?
I'm just covering all my bases to make sure that any kind of that the contraband that was seized, nor any statements that were elicited during interrogation are not suppressed later on.
All right, so are you going to be asking that his statements be suppressed if the court denies your motion?
No.
I'll move on, Judge. Officer, I'm approaching you with what's been the state exhibit number 1 and 2. Can you identify these two items?
one's gonna be mine. One's my body cam, and the other one's gonna be my dash. Dash cam.
Have you viewed both of these items?
Yes,
Are they clear and accurate representations of what you saw that evening?
yes,
Any sign that they've been doctored, altered, amended, AI, anything like that?
no,
Was your dash camera and your body camera working correctly that night?
yes,
Were you trained on how to use them?
yes,
And did you use both of them in compliance with your training?
yes.
Judge, the state wishes to offer state exhibit 1 and 2 into evidence and any objection.
All right,
Objection.
and I'm sorry, state's exhibit number 1, is that the body cam?
State exhibit number 1 is going to be the dash camera.
Mhm.
And state exhibit number 2 is going to be the body camera.
All right, then state's exhibit 1 and 2 are admitted for purposes of this hearing only.
Permission to publish it?
Granted. John, what is happening with your case? All right, just one moment before you publish that. If you'll come forward. Oh, your client?
That's one.
So we can have him.
I'm starting an armed robbery trial tomorrow morning in the 290th.
Okay. I'm just trying to find the page. Your
Antoine
client's-
Irving.
I'm just trying to find him on the docket.
I think it's like the 3rd page.
Ah, here we are. So, Norma, set this for jury trial the week of the 17th. All right, August 18th.
Thank you,
Once you
Rob,
find the reset form, you're excused.
for next week. Thank you, Rob.
You're welcome. All right, State, you may proceed.
Thank you, Judge.
And Deputy Laura, the other inmates?
He's the only one left. He is Anita Perez, his client.
All right. Just one moment. I'm sorry. I'm sorry. Norma, see if Laura Lefton is still in the building. And state you may proceed.
Thank you, Judge. Publishing State Exhibit number 1. Officer Vasquez, this is a view from your dash cam.
Yes.
The speed limit on this road is 45.
Yes.
You know what road it is?
FM 78.
Now you're performing a turn here. What did you observe?
Observed a white vehicle.
The white vehicle that you observed speeding?
Yes, that's correct.
We'll see you tomorrow, sir.
The record now posting State Exhibit number 2.
Oh, sir. Sorry, sir. I'm sorry about that. I know it was probably like 65.
Actually, it's a 45 horse speed limit, you're going 70.
It's not 50 right here?
No, so it changes from a 50 to 45. So
I'm sorry.
okay. Here, if you want. Where are you heading to right now?
That is
Shirts. Oh, what are you saying?
20,
Place. Something. Where are you coming from?
college.
First. Okay. Oh,
210, 716.
and I'm getting all messed up right now. Hold on. I-
It's like the first you see it.
Oh, okay, 7-1. And the recurrent track.
Insurance probably come back to like.
A group insurance?
My bad, like, I'm on my mom's plan.
Okay.
It's like 4 months. Are you universal or?
University. Officer Vasquez, University. Sorry.
I seen well, the SAPD, they was stacked up over on 604. Some back down.
Man, I'm not too sure, man.
Y'all not like close like that department wise?
No, so we work within ours. Can you open your door so I can scan the numbers?
And then, no, right there.
Yeah, but it's not scannable. So I'm gonna just scan the,
I put up a phone to one there.
I was gonna just scan the sticker you have on your door. It's Infinity, Q50. Okay. And what years? 2020. You said the insurance is gonna be under who else's name?
Christie, Michael Hill,
Somebody go.
and Sarah's on that, everybody should be on that plan.
Okay, awesome. Right, I was like. 4-3-3-3. 6-0. 4-6. That's your vote. Right.
Yes.
All right. What is it?
Vehicle.
Yes. Yeah, and weapons on you. So, go ahead, turn on the generator, right? Turn on the generator.
Officer, for the record, what's the timestamp on the video at this time?
Every time I point out, I see those type of defense like that.
Again?
0240.
0240, thank you.
Okay, could you rewind that back?
My apologies, Judge.
I'm going to look this way simple. Every time I point out, I see those type of people and stuff like that. Okay. And else here, it's, which is fine. But you know, it just didn't seem like some jump in. But that's fine. And also for they understand that it's I can see nothing on the rest. You just beat the same. And whether they said do something like that, or something that I'm never in your head. You don't have any, that's just. Where do you think the thing?
What? Just location.
So with the search badge watch. Right.
Officer Vasquez, you said, why are you waiting to conduct the search right now?
Waiting for a secondary officer.
Okay, and is that in compliance with your policy and procedures, for your city?
Yes.
Continuing to.
Judge,
Yes.
one of our motions was they're gonna rely on documents that we could give a copy to those. This might be short notice, but I don't have any copies of the policies. and procedures. If the state has them, I would like them, but obviously I don't want to delay this. To wait.
Oh, no, I'm here to listen. So did you bring policies and procedures with you? Oh, all right. How long will it take you to get policies and procedure?
Unsure.
All right, so let's do this. If you can step down and call whomever you would call to see where the policies and procedure manual is, if you all have one.
Verify. Great.
All right,
Yep.
thank. All right, so I'm gonna let him step down and do that if there is no objection.
No
And then if they
objection.
don't have a manual, if it's just something that people say, then that's what we deal with. All right, so if you'll step down and if you will see if there's a manual or something. And then council, if there is a manual, if you could let me know how long it will take to get the manual here. All right, thank you.
Proceed.
All right, you may continue, state.
So, officer, let me ask you a few quick questions. What is that little item that was on your phone?
What I,
The item that we were trying to use to scan the registration sticker, what is that?
that's a electronic ticket writer.
Okay. So is that standard issue for Universal City Police Department?
Yes, it was issued to us for patrol.
Is it standards? I'm sorry.
It's for, so it was issued for the police department and our codes enforcement. And also fire marshals for our fire department.
Okay. And is it standard for you or standard for the department to scan the registration of every vehicle that you'll pull over?
It's common practice, yes.
Okay. And I saw, was there a problem scanning the sticker?
Yes,
Okay. And I saw you ask the defendant to open the door. Did you ask him to open it or order him to order it? Order him to. Okay. And he did comply?
he did.
Were you able to get a clean scan off of the registration sticker or the registration barcode on the inside of the door?
The barcode inside the door jam, yes.
Okay. And you do that for everyone, right?
Yes, if I can't scan the registration, I'll just see if I can scan the barcode inside.
Okay. Okay, let me ask you, what time of day was this? What time of day was it?
It was 9.
Okay. Are you able to see the race, gender, or number of persons in a vehicle when it's driving by you at 60 miles an hour at night?
No,
To your knowledge, that could be anyone that was driving 70?
yes,
Okay. 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 Judge, we'll continue playing state exhibit number 2.
Okay.
Ask for a little bit more search. Wow.
Yes.
And I just overheard counsel sitting and fast forward to the search. I would represent to the court if the counsel is okay with it. Israel is eventually put in the car before the search commences, I believe. We're not challenging anything after this. I don't think we need to. Obviously, it's their case, it's your court, so there's nothing after this for challenge.
Okay.
And so I would object for that purpose too,
All right.
and the need to show anything else.
And if I may respond, Judge.
Yes.
I am merely fast forwarding to show the amount of time in between the detention and the actual search. As defense counsel stated, the length of time, the prolonging of the stop was one of their contentions. I believe I need to show the amount of time that took place in order to rebut that.
In this case.
The objection will be overruled.
Thank you, Judge. Now pause it right here. Officer, is this when you began the search?
yes.
Okay. And what is the timestamp on your body camera?
0246.
And the initial detention was at 0240,
Yes,
so 6 minutes have elapsed.
yes.
Officer, answer this plainly. Was there any kind of racial motivation or profiling into what you did regarding the stop or the search or the detention?
No.
Judge will pass the witness.
Defense?
May I proceed, Judge?
Yes.
Is it Officer Vasquez? Yes. Officer Vasquez, I'm Jason Todd, I represent Mr. Hill. If I ask something that if I don't communicate well, just let me know. Sometimes I get a little excited or talk a little fast. Or not loud enough, there's lots of reasons why you might not understand it, have everything to do with me. So I will try to do things the best I can, but please, it's no offense taken if you need me to repeat them. Right? So on the stand, you said, and I just want to be clear, the only reason you searched the car is because of the smell of marijuana. Is that correct? Correct. Okay. And then in the video, what we're seeing though, is that you mentioned that you're doing it because he appears sweaty, he appears nervous, he appears hesitant, that he could not see, and I listed a bunch. Do you need me to go through those one at a time?
Is that all that's on the list?
I'll go through one at a time. Okay. On the video, you mentioned that he appeared sweaty. Was that a reason for the search?
No.
Okay. On the video, you mentioned that he appeared nervous. Was that a reason for the search?
No.
Okay. On the video, you mentioned that you could not see into the back of the vehicle. Was that a reason for the search?
No.
On the video, you mentioned that he was hesitant in opening the door. Was that a reason for the search?
No.
Okay. On the video, you mentioned that you were uncomfortable with the situation.
Correct.
Was that a reason for the search?
No.
No. Okay. So the only reason you made the search was because of the odor of marijuana.
Yes.
Okay. You mentioned that it wasn't clear to me what training and experience you have in the odor of marijuana. Will you please list the trainings you've had in the detecting the odor of marijuana versus the odor of hemp?
So during my training at FTO, we made encounters and arrests off of marijuana.
I'm going to object to non-responsive.
Sustained.
Specifically, what trainings have you taken on detecting the odor of marijuana versus the odor of hemp?
I don't know how I answered the question.
Have you had any training specifically on the odor of marijuana versus the odor of hemp?
No.
Are you aware that for a time, and specifically at this time, that hemp flower or bud was legal?
No.
Okay. Are you aware that hemp flower or bud has a similar smell to marijuana?
No.
Okay. You would agree that Mr. Hill was cooperative with you, correct?
Yes.
Okay. And would you agree that he was not nervous?
No.
Okay. So you would say that he was nervous?
Yes.
Okay. What in the video indicated that he was nervous?
First encounter where he kind of had to think about his age.
Okay. What else?
Then I asked if he opened the door so I could scan the VIN number. Hesitant. Okay. But from there, also sweating from where he was coming from. That he was driving a vehicle and he was sweating.
And I want to break that apart. You said sweaty due to where he was coming from. Is that what you said?
From where he was inside the vehicle. Sweaty inside the vehicle.
Okay. So because he was sweaty in his vehicle, you saw that as a sign of nervousness.
Yes.
Did he give you any other reason to be sweaty?
So he was coming from Gold's Gym.
Is there a Gold's Gym near this area?
Yes.
Is there a Gold's Gym on Pat Booker like he told you?
Yes.
So would it make sense that he was sweaty because he was coming from Gold's Gym?
Awesome.
Okay. Would it make sense that he was sweaty because it was July in Texas?
Yes.
So there's another reasonable explanation for his sweat, correct?
Yes.
You thought that he was hesitant in the way he opened the door, correct?
In the way he opened the door, no,
I'm sorry, the timing of opening the door or his willingness to open the door.
yes,
Now, you said you couldn't read the VIN, is that correct? Under the window.
my ticket right couldn't read the registration.
So you could see the registration. With your eyes, your ticket reader had some sort of reason it could read, correct?
Yes,
And then you come to his door and you scanned it inside his door, correct?
yes.
Why did you go back to look at the front VIN again?
So when I scan the barcode, it auto populates the VIN number. And from there, not the registration, but the actual VIN number to match both that are correct. That they're the same.
Okay, I understand that.
You
Tell me, why did you go back to look at the window? That's what I don't understand.
So there's your registration sticker, right? All right, at the bottom, there will be a VIN number. So I match from the code from the door jam to the VIN number that's on the windshield.
Why do you do that?
So it's very common for, if you heard of VIN swapping. So they stolen vehicles or salvaged vehicles will be purchased, and a stolen vehicle will basically swap the salvaged VIN numbers to that new vehicle.
So you're checking to see if the vehicle was stolen.
I'm checking if the VIN numbers match from the door jam and the VIN number on the windshield.
In your police vehicle, do you have a way to run the license plate to see if it goes to a particular car?
Yes,
Okay. Had you done that before prior to the stop?
dispatch did. I didn't manually type it in. I radioed in, and it will auto populate on my cab.
Okay, what information did you get when you did that?
The vehicle's information, Mr. Hill's vehicle.
And did Mr. Hill's vehicle match up to Mr. Hill?
I believe so, yes.
And so when you went to the window, in your mind, this was a vehicle owned by Mr. Hill, correct?
Correct.
And then when he gave you his ID, he confirmed that he was the owner of the vehicle, correct?
Yes.
Why did you need to check for the swapping if at that point in time you knew the vehicle was his?
If I may. So there's been. So when it comes to VIN swapping, the registered owner will come back to the driver. Now, if there's any identifying marks, like if the VIN plate is not in the right position, or if it's fictitious, or if you can't see the VIN number in the windshield, you double check for that.
Did any of those things exist in the case of Mr. Hill?
At that point, no.
So there was no indicators that VIN had been swapped when you looked at the VIN?
After confirming both VIN numbers match.
I'm sorry, I guess I misunderstand, because what I understand you just to say is that if he had swapped out the VIN in the window, there'd be some sort of indicator, maybe it's a skew, maybe it's scratch, or maybe it's something like that, and that would give you a clue that although this car registered to Mr. Hill and with Mr. Hill in it is not his car.
Correct. Or the wrong VIN number on the windshield.
So prior to scanning it, was there any indicator that VIN was the wrong VIN number?
No.
Was there any indicator that the VIN had been tampered with?
No.
No further questions, Your Honor.
Brief your right, Judge.
Yes.
Officer. You do this ticket writer scan for every vehicle you pull over, right?
Yes.
Did you coerce Mr. Hill to open the door?
No.
Did you order him to open the door?
No.
Did you draw your weapon and tell him to get out of the vehicle?
No.
Did you ask for consent to scan the barcode inside the door jam?
Yes.
And what was Mr. Hill's reaction?
He complied.
So you had consent to scan the barcode inside the vehicle.
Yes.
No further questions.
No further questions, Your Honor.
All right, is the witness excused?
Excused by the state, Judge.
Nothing else from the defense, Your Honor.
All right, thank you. If you'll leave the exhibits with the court reporter, please. All right. State, you may call your next witness.
State will rest, Judge.
Defense?
Defense rest, Judge.
All right, the court will hear argument.
Judge, the state reserves for rebuttal.
This is my motion, Judge, so
Yes.
we'll reserve for rebuttal.
In that case, I will go then.
Oh, officer, you're excused. You may step down.
Judge, I have 4 cases that I would like to present to you for your review. They would be Pennsylvania v. Mims,
Mhm.
citation 434 US 106.
Okay.
Johnson v. State, which is a memorandum of opinion out of the 14th Court of Appeals of Texas. And Stringer v. State, which is 605 Southwest 3rd, 693. And lastly, Morgan v. State, citation 906 Southwest 2nd, 620. I would like to present those for your review, Judge.
All right, thank you.
May I approach?
Yes.
Judge, the state has the burden to show that under 38.23, there is no illegality on behalf of the state in acquiring evidence against the defendant. And Judge, I believe that we have done that here. The traffic stop was done legally. Mr. Hill was found going over the speed limit in a 45-mile-per-hour zone. I believe in the video, he even admits that he was going 65. When the officer came up to the window, he said that he smelled the aroma of marijuana coming from the inside of the vehicle. And that goes to Johnson v. State, which I'm sure defense counsel will bring up that there is no difference between the odor of marijuana and the odor of hemp. However, Johnson v. State says, and I quote, Officer Scarrow testified he smelled what appeared to be marijuana, burned marijuana emanating from the vehicle while questioning appellant during a
All right,
valid
you're
traffic stop.
reading too quickly for the court reporter.
I'm sorry, Judge.
Thank you.
It is well settled that probable cause to conduct a warrantless search of a validly stopped vehicle exists when the searching officer, experienced in detecting the odor of marijuana, smells burned marijuana emanating from the vehicle. Appellant's probable cause challenge is founded on Officer Scarrow's cross-examination explanation that he only reported smelling what appeared to be marijuana based on his previous police experience because he did not want 100% to say it was marijuana and be wrong, and that he could have been wrong about the smell, but probable cause deals with probabilities requiring more than mere suspicion, but far less evidence than that necessary to support a conviction or a finding of preponderance of evidence. The law does not require Officer Scarrow to have 100% certainty that the odor he smelled emanating from the appellant's car was in fact first marijuana odor. Judge, the fact that there is no difference between the odor of hemp and the odor of marijuana is a moot point. Both smell the same, but marijuana smells like marijuana, and that is still an illegal substance under the state of Texas. Further, that goes towards Stringer v. State, which says, and I quote, a strong odor of marijuana from a small enclosed area like a car gives a peace officer probable cause to make a warrantless search of both the car and its occupants. As marijuana possession is a crime, its odor evidences criminal activity. Thus, the strong odor of marijuana may give a peace officer probable cause to make an arrest. And lastly, Judge, I believe to the defense counsel's point that he ordered the defendant out of the vehicle, I go to Pennsylvania v. Mims, which states, and I quote, the state freely concedes the officer had no reason to suspect foul play from the particular driver at the time of the stop, there having been nothing unusual or suspicious about his behavior. And we have specifically recognized the inordinate risk confronting an officer as you approach a person seated in an automobile. We think this additional intrusion can only be described as de minimis. The driver is being asked to expose to view very little more of his person than is already exposed. The police have already lawfully decided that the driver shall be briefly detained, that the only question is whether he shall spend that period sitting in the driver's seat of his car or standing alongside it. Not only is the insistence of the police on the latter choice not a serious intrusion upon the sanctity of the person, but it hardly rises to the level of a petty indignity. Pennsylvania versus Mims basically states that an officer can ask someone out of the vehicle during a traffic stop for little or to no reason, whether it be officer safety or whether to conduct a traffic stop in the back of the vehicle or to the side of the vehicle out of the way of traffic. Basically, Judge, this comes down to the officer performed a traffic stop. He smelled the odor of marijuana immediately coming from the open window. He observed the defendant inside of the vehicle. And I'll lastly go to Morgan v. State, which says, and I quote, "The VIN, which was the clear initial objective of the officer, is by law present in one of two locations, either inside the door jamb or atop the dashboard, and thus ordinarily in plain view of someone outside the automobile. Neither of those locations is subject to a reasonable expectation of privacy." Not only is the scanning of the VIN standard practice of this officer that he does to all people, regardless of day or night, race, color, creed, or anything else, it is also not protected by the Fourth Amendment. There is no expectation of privacy in the VIN on the dashboard, nor the VIN on the door jamb. The officer was within his rights and even asked politely for the defendant to open the car door so he could scan it. He had consent, which further waives any kind of Fourth Amendment protection. And after all of this, the officer only detained the vehicle for 6 minutes. He did not ask for a drug dog to come by and do an open air sniff of the vehicle. He did not prolong the stop any more than was necessary, even though he had probable cause to search the vehicle as soon as he arrived at the driver's side door.
Did he say on the video that one of the things he found suspicious was the fact that he was hesitant to open his door for him to look at the VIN number?
He said that, Judge. He also laid down a number of other reasons, but
my question is, he said that.
Mhm.
And so from the video, my question becomes, was the defendant hesitant to open his door?
Judge,
Because I didn't see that on the video. And if somebody can show it to me on the video where he's hesitant to open his door, then that's my mistake. So was he hesitant to open his door?
Judge, the defendant did ask why, and there was a bit of a hesitation and a pause.
Okay.
But I don't believe that ultimately it is subjective as to whether there was hesitancy or not.
Okay.
But the odor of marijuana is beyond being subjective. It is an objective standard that can be recognized by this officer who, through his training experience, can smell the odor of marijuana. Would you like, I can play the video again,
Yeah.
Judge, if, of course.
Thank you. I wanted to make sure I heard everything correctly.
No, so we work within our city. Can you open your door so I can scan the VIN number, sir? Yeah, but it's not scannable. So I'm gonna just scan the. I was gonna just scan the sticker you have on your door. Yes. All right. Yeah, what?
Thank you.
Thank you. Summarize, Judge. There's been no violation of Article 38.23 of the Code of Criminal Procedure. There was no illegality on the part of state agents to acquire the evidence or contraband that was found in the vehicle. Everything has been in compliance with the case law and with the laws of the state of Texas. No illegality has occurred. Because of that, The exclusionary rule under 38.23 is not triggered, and we ask that you deny the defendant's motion to suppress.
All right, defense?
Judge, may I approach with my cases?
Yes.
Judge, the first case that I will be citing, and I'll go through them by name when I get there, is Rodriguez versus the United States, 135 SCT 1609. The second is the state of Texas versus Dominguez, which is 714 Southwest 3rd 42. The third is Seifert versus State, 290 Southwest 3rd number 478. And then the final one is Isaac v. State, which is all I have is the actual, it's 2023. I apologize. It's 675 Southwest 3rd 116.
And State, have you had a chance to review their cases?
I have, Judge.
All right, thank you. All right, you may proceed.
Yes, Judge. So, Judge, what we're challenging is under the Constitution, it's under the Texas Constitution and under the Constitution of the United States, that we are to be free from unreasonable search and seizure. What the argument in this case is that this is an unreasonable search due to an unnecessary delay and an unreasonable delay. That's what makes this an illegality. If you look at Rodriguez v. State, Your Honor, this is a Supreme Court case from 2015. And if you go to Roman numeral 2, which would be 2, 3, 4, 5, 6, 7 pages in, and I apologize if they're not numbered. What that court said is that, like a Terry stop, the tolerable duration of the police inquiry into the traffic stop context is determined by the seizure's mission to address the traffic violation. Addressing the infraction is the purpose of the stop. It may last no longer than necessary to effectuate that purpose. Authority for the seizure thus ends when tasks tied to the traffic infraction are or recently should have been completed. It goes on to say that officers may not act in a way to prolong the stop absent the reasonable suspicion ordinarily demanded to justify detaining an individual. And what that ordinary standard is that there are specific articulable facts for that detention. If we look at State versus Dominguez, this is a case where a person was pulled over. It was a person who the officer was, so in Dominguez was pulled over by an officer that was familiar with him. He'd been following him around town. They said Dominguez was nervous, his hands were shaking, he lit a cigarette to attempt to calm his nerves. They saw a radar detector in the vehicle. They thought that was suspicious, and they found a faint odor of marijuana. They thought he was in the drug business. And what the court says there is reasonable suspicion to detain a person exists when a police officer has specific articulable facts. A traffic stop made to investigate a traffic violation must be reasonably related to the purpose. So this is taking the Supreme Court case. This is the Texas case that continues that idea in Texas. Judge, the argument in this case is that there aren't specific articulable facts to prolong this. What this officer discussed was he originally said it was based on the smell, and then in listening to the video and in cross-examination, he brought up other reasons that may have led to the stop, although in the video he mentions them in the body cam video, but then on the stand he said they weren't. So it's not really clear to me where he is on those issues. The point being, Judge, is that first of all, if he thinks that Mr. Hill was nervous or hesitant, I think the body cam, I would argue the body cam speaks for itself. Mr. Hill did what we hope anyone being pulled over would do. He had his license ready. He was polite. He was apologetic for he understood that he was speeding. There was some discussion about how much. He did everything someone is supposed to do. And in response to that, based on a smell, he was pulled out, cuffed, and eventually put in the back of a car. That's what prolongs this. The stop was effectively over. If you look at Seifert versus State, this is another case that continues along that line. and I won't go into all the details, Judge, but it is a case that would say, the legal justification of the purpose of the stop was to either warn or cite the driver when there's no reasonable suspicion to conduct any other investigation, or is just based on a hunch. Officers cannot continue stops and continue investigations that detain somebody based on a hunch. And that's what this officer seems to be doing. Finally, Judge, I present you Isaac v. State. I will admittedly say that the nature of the smell of marijuana in a vehicle is mixed. What all the cases prior to Isaac say, Judge, is that it's got to be based on a totality of circumstances. Isaac v. State, it's brought up, look, the smell is not enough. And what the court says is, look, marijuana is still illegal. But in this case, it's part of it. The smell can be part of it when there's a totality of circumstances. And then they go on to list the other circumstances to proceed. The smell of marijuana by itself, there's been no case presented that that's enough to continue this investigation. And that's all there is. For those reasons, Judge, I would say this was an unreasonable delay, that the illegality is putting Mr. Hill in cuffs and putting him in the back of the car when there aren't specific articulable facts to continue the stop. And for that reason, we would ask you to suppress everything after the initial stop.
All right, so here's my question, and if parties want to address it, they can. All of the case law basically says a variation of the same thing with traffic stops. The first thing is that when you have a traffic stop, the stop must not last no longer than necessary to address the purpose of the stop. So in this case, I think both parties have stipulated to, and the evidence shows that the stop was for a traffic violation, and that traffic violation being speeding. So an officer can question someone with regards to the speeding. You know, are they going to write them a ticket? Do you have your insurance, your license, your registration? Does anyone want to address that?
Judge, I would address that in two ways. First of all, if I may. First of all, he had the ticket writer in his hand. He said that. So he can write the ticket there. I think, so that would be that it's done. That he had all the information he needed at that moment to stop it. I think the second issue, Judge, though, is, in addition to that, is the smell of marijuana is based on the officer's credibility. There's no extrinsic proof. So first of all, I don't think he's qualified. That's my argument. That's for you to decide. That's one argument. The second is, you have to believe, if you believe everything he said about this stop, I find it incredulous what he said about the stop. That Mr. Hill was hesitant, that he was nervous, that he acted in any way inappropriate. All of that goes to his credibility. And the smell is only based on him. So even if you believe the smell's enough, you still have to believe him. And so first of all, yes, with the ticket writer, that stop was done. But second of all, I don't know how someone can believe that he smelled it if you listen to everything else he said.
May I respond, Judge?
Yes.
Judge, the initial reason for a traffic stop does not then bind the officer to that reasoning. If the officer pulled over the defendant or anyone else for speeding, and there was a dead body strewn out in the back seat, the officer cannot then say, by that logic of the defense, he was only pulled over for speeding, ergo, pay no attention to the dead body in the back of the trunk, I can only do a citation for speeding. The reason for initial detention can metamorphose as the evidence further makes itself known. In this case, the officer said that he pulled the vehicle over for a reasonable traffic violation. And then when he approached the open window of the defendant, he smelled the odor of marijuana. And I believe defense pointed to Isaac v. State. In that opinion, the Fourth Court of Appeals does say that while the odor of hemp, and hemp is legal, marijuana is also illegal. They may both smell the same, but the smell of marijuana evidences the showing of contraband. So Judge, that is going to be our contention that this was a reasonable traffic stop. It was a detention, which then once the officer smelled the odor of marijuana on top of other factors, the time of day, his subjective opinion of the nervousness of the defendants, the fact that he was sweating, all of those go to the totality of the circumstances in his mind that he is justified in performing a search of the vehicle. And Judge, I would further state that from the defense counsel's own case law, that the smell of marijuana is still evidence of contraband being inside of the vehicle.
But does opening the door or requesting that the door is open to search the VIN number, does that have anything to do with the traffic ticket?
I don't believe so, Judge, but he did ask for. Yes. Judge, the state is already putting case law that says that there is no reasonable expectation of privacy in the VIN number that's on the door jamb or the VIN number that's on the dashboard of the vehicle. Even more so, the officer asked the defendant for consent. He asked if he could open the door. He at no point ordered him. He at no point drew his weapon. He at no point tore him out of the vehicle. He asked, and the defendant complied. There was no Fourth Amendment violation, and there is no, from the case law, there is no Fourth Amendment protection to be had here.
No.
The officer was completely within his rights to do so.
No. According to the case law, if you pull somebody over for speeding, the time delay has to do with how long is it taking you to investigate or to address the issue for the stop. For example, if you're pulled over for speeding, does that mean that somebody opens their door, you take the VIN number off the door? We're beyond whether or not he consented to opening the door. He opened the door. But I go back to the point, for all of the case law, it says whatever the violation is, whatever traffic violation it is, the actions that are being taken by the officer or who, whatever agency pulled a defendant over, are those actions related to whatever the traffic offense is?
Judge, from what I remember the officer testifying to, that was his standard procedure. The UCPD officers are issued that ticket reader, and they do that for everyone, for every traffic stop that he does.
But just because they do that, does that mean that it's right? It's the question I go back to is, if you're pulling someone over for speeding, and the law says, all of the case law, all of the cases that the state has given me, the defense has given me, in some form or fashion, they go back to whatever traffic violation you're pulling someone over for, the officer is supposed to be addressing that issue. If it's running of a stop sign, all right, how are you addressing it towards the running of a stop sign? And so in this case, I think both parties agree that the defendant was speeding. In the video, it says that he was speeding. In the video, he admits to speeding. Nobody's going to suppress any statements. So the question becomes whether or not, when he was stopped for speeding, the actions that the officer was taking, was it to address the speeding? Now, of course, if there's a dead body in the back of the car and somebody sees a dead body, that's completely different. But the first thing becomes the ticketing for the speeding.
And just, if I may address that concern.
Yes.
So, from what the officer said, well, first, from the case law that was given by the defense, I overlooked it, and it has to do with the prolonging of the stop, whether a dog was called out to do an open air sniff around the vehicle. In some of those cases, I've seen those cases, Judge, they take hours to get there, 15, 20, 30 minutes. Here, the only amount of time between the detention and the search of the vehicle was 6 minutes. I would argue that this amount of time, compared to the other case law where the stop was prolonged, where the stop was prolonged to 20, 30 minutes, Compared to that, 6 minutes alone is a de minimis and a small intrusion into the defendant's Fourth Amendment rights.
But Judge,
Hold on,
Judge,
if I may.
Oh, just 1 second. If you let him finish, then I'll.
I'm
hear-
sorry, Judge.
No, no, no,
I'm sorry,
no, it's no problem. I'm gonna hear everybody.
forget my manners.
That's okay.
And further, Judge, he was going through the motions of writing him a ticket. He had his ticket writer out that was issued to him. He was trying to scan the VIN of the vehicle on the dashboard as well as the door jamb. All of this was still in compliance with the ticket writing procedures that he had done. And that was after he had already smelled the odor of marijuana emanating from the vehicle. Because of that, Judge, this stop was not prolonged further than was necessary, even though the officer had probable cause to perform a search. And because of that, Judge, he is justified in his actions.
Yes.
The point is that even a moment too long is too long. A moment of a violation of the Constitution is too long. And that's the point here, Judge, is Mr. Hill's constitutional rights were violated because he was held too long, because the reason for the stop was complete.
All right. And here's the court's other, oh, you all may be seated.
Thank you, Judge.
And if
Here's
may I-
my question though.
Of course, Judge.
And then I promise you all can argue as long as everyone needs, because I want to make sure that the questions I have are addressed. And it appears from the officer's testimony that his checking of VIN numbers is because that's his policy. Am I wrong in that?
Judge, I spoke with the officer that
Well, no, I mean his testimony.
his testimony is that he needed to do this because that was how the ticket writing cell phone that he had works. He has to scan the number, it auto populates so that he may issue a citation if he chooses to. He may issue a citation or he may issue a warning, but that is part of what he needs to do in a stop. And this was after he had already approached the defendant's open window, and after he testified, he already smelled the odor of marijuana coming from the vehicle. So, Judge, we would argue that the officer had probable cause at the moment that he arrived at the open window of the vehicle, and this was before the reason for the stop had concluded. The officer, in the middle of performing his investigation of the traffic violation and possibly issuing a citation, already had probable cause to move on to the next step, which was the search of the vehicle, which is the automobile exception that we all learn in law school. Because of that, Judge, the prolonging of the stop is a moot point because the reason for the stop had not yet completed. The officer had not yet decided to, and had not yet done the decision to issue a citation or issue a warning. It was in the investigation of the traffic stop that this metamorphosed into probable cause for a search. Because of that, Judge, because there's no prolonging of the detention, as the reason for the search was within the confines of investigating the traffic stop, I believe that the officer's actions are justified and no illegality exists.
I think you have it all in front of you, Judge, and I'll rest on what we've already.
All right, thank you.
Thank you, Judge.
All right, I just need some time to watch the video. So if y'all will play the video again, please.
Okay.
Rewind it, Judge?
Yes, that's not the beginning.
I'm sorry, and I'm not understanding, Judge. You just
Did I go back more? Okay. Bueno, good. Okay, let's start again.
It's infinity, P250? Okay. What year is it? 2020.
Oh, no, he's already outside the car.
Let's fast forward now. Okay.
everybody.
All right, we will all be back
I'm sorry?
tomorrow.